Hi, good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. And so the theme kind of this week has been criminal law, because a number of you are taking criminal law right now. So I thought it would be perfect to have a couple of defense counsel on, as well as others in the system. Today's guest is also a criminal defense lawyer, like Michelle from yesterday, Harpreet Saini, and he is going to talk to you about his practice and criminal law and just some other fun things as well there. So definitely looking forward, Harpreet, to listening to you. And maybe you can start kind of telling us what drew you into criminal law in the first place. Was it something that you always had a passion for, or did it kind of develop um, later on and after you started your career?
Sure. Well, I kind of fell into it. Um, and the reason I like telling people that is because you hear so many other lawyers tell their inspirational stories of, I've always known ever since I was a child that I wanted to do criminal defense. And that can be disconcerting because for a lot of people, if you don't know what you want to do, and then you hear those people say those things, it may freak you out because you may think to yourself, well, if all those people knew and I don't know what's wrong with me. So don't worry. There are a lot of people who knew right from the beginning. I didn't know. I did my undergrad, and then after I finished my undergrad, I didn't know what I wanted to do. So what do? Instead of making a decision, I punt it for 4 years, and I go to law school. You go to law school for 3 years. Do I know what I want to do? Do I know what I want to do? No, absolutely not. So you interview at a couple different places, and you hopefully find a place. And then I only interviewed with one place. I got one interview, and it was a criminal defense firm, and they hired me. So that's how I became a criminal defense lawyer. Now, don't get me wrong, it turned out great for me, and I loved it from the get go once I got into it. But I had no clue that that's where I would end up. It's just the fates smiled down on me. I got one article interview, and they ended up hiring me. So there you have it. So don't freak out if you don't know right from the get go.
And maybe you can elaborate then more on kind of after that and what led you to having your own practice and what it's been like to be a criminal defense lawyer with your own practice and maybe kind of give us a little bit. I know obviously as a criminal lawyer, every day is different, but kind of what are the different things that you work on so that students can have an idea of what awaits them if they get into a career in criminal law.
Sure. Well, I articled with one office, the office of Hicks Block Adams. It's now called Hicks Adams. I was there for 9 years as a lawyer after articling. It was a great place. I had a great experience there, but at a certain point, I had kind of capped out as far as my level of experience was going to go. I was senior there. They let me do my own thing, but I felt it was time for me to branch out and try something new and try something different. So that was around 7, 8 years ago, give or take. That's approximation. And then I decided to go out on my own, and I've been out on my own ever since as a sole practitioner, trying to make it go. The firm experience was good for me, even though it was a lengthy time period for me. I needed that learning curve. I needed the mentorship. I needed people to kind of show me the ropes. That's just the type of learner I am. And once I got to that point where I didn't feel I had any more to learn from that place, that's when I decided it was time for me to head out. As far as my day to day now, everything's different, of course, now than it was a year and a half or 2 years ago. But a lot of my work is in the OCJ, Ontario Court of Justice. So a lot of my work is in the lower courts. On the other hand, a couple times a year, you'll have a bigger case in Superior Court. So I'll spend a month on a jury trial or whatnot. Let me just shut off that phone so it doesn't disturb us anymore. Sorry. But most of my cases are low court cases, and then a couple times a year I'm going to have a couple more serious cases. So there's a healthy mix, and I like it that way because I don't want to be one of those lawyers who does so much serious stuff, so many serious cases that you forget how to run the little things, and you really can forget. On the other hand, I'm senior enough that I do feel the need that I can go do more serious cases as well. So I try and keep a healthy mix. My day to day now, though, is mainly prepping in my office, and then you go to court for trials, you do your Zoom set dates, et cetera, just like everyone else. That was kind of babbling and kind of long winded. So I'll leave it to you. Did that help?
Yeah, I mean, I think maybe you could look at kind of, let's compare, the
Sure.
time there. I mean, I think certainly for those in law school, they learn all about the theory, and we don't learn as much, or maybe it's different today than when I went and when you went, about kind of, well, what it's like actually running a practice, or being, an associate at a big firm. And maybe you could kind of highlight some of the things that you would have to do at Hicks Adams, that you don't have to do here now on your own, and vice versa. I mean, obviously coming on your own, there's all sorts of things like docketing and um, accounting and things like that you may not have had to do previously. And obviously, though, it's different being an associate, where you're kind of getting a salary versus you eat what you kill, so to speak, as a sole practitioner.
Thank you. So what I would want to stress to students who are listening is that what you learn in school is important, but a lot of what you learn once you get out into the field itself, you kind of have to learn as you go. So even as if you're an associate, forget the business end for a second, and you're just an associate. The day-to-day machinations of the criminal justice system is very different from what you learn. It's important to learn about the mens rea and the actus reus and all that sort of business, and it's great to learn that. On the other hand, that's not going to necessarily help you when you have to pick up a bail hearing on a Monday morning for a guy who's arrested over the weekend, and you're trying to juggle a surety calling you, maybe four other potential sureties trying to call you, someone trying to making arrangements to try and get paid by somebody. You got to speak to the client in the interview rooms downstairs, or the phone if they're at the division, trying to put together a bail plan last second, knowing full well that at 9:30 court starts and you have to be ready to go on your bail hearing. So knowing that you got to contact the Crown Attorney to get the synopsis, see what their position is on bail, knowing who the Justice of the Peace is, and we're thinking to yourself, is this a day where I should run this bail, or is this a day when I should potentially adjourn this bail if I'm not ready to go, or for whatever reason. These day-to-day administrative things, these day-to-day nuts and bolts, that's not what you're going to learn in law school. You get your foundations in law school, or whatever college you go to, but your day-to-day is the administrative stuff that you learn, and dealing with clients, handling and dealing with very vulnerable people within the very fragile states. That's something you're going to learn as an associate once you actually begin to practice. That law school does not teach you, or colleges don't teach you necessarily. Another thing that you will learn once you become an associate that you don't necessarily learn in school is the importance of the social services aspect of what you do. So much of what we do is getting people hooked up with counseling services, getting people hooked up with a shelter, getting people hooked up with an addictions program, et cetera, et cetera. School doesn't teach you how to do that. School's not going to give you that phone number, that list of phone numbers. That only comes once you go out there and practice. And then beyond that, once you leave being an associate and you start working on your own, you're doing all those things, but now you're also dealing with the business end of it, which again, school does not really prepare you for very well. You have to deal with legal aid billings or cash billings. How do you maintain a trust account? When can you move your money from your trust to your general? Why do you need two separate accounts? Spoiler alert, you need two separate accounts. All the accounting rules that come with maintaining a trust account, et cetera, et cetera. These are things that are crucial in running your day-to-day practice, but you don't learn it in school. And then I'll throw even one more thing at you. Even once you're out on your own and you've kind of figured out that stuff, then you may need to learn how to do payroll, because maybe you now need to hire staff. You need to learn about benefits. You need to learn about HR. You need to learn about what you can and cannot say with an associate who is now under your payroll, or staff under your payroll. When can you fire them? What reasons can you fire them? Et cetera, et cetera. So all these things are things that come after you finish your formal education, and there's a lot, unfortunately.
And so we kind of talked about, and certainly now we're well into the pandemic, and we've had different changes here and there. What could you maybe share from your experience there on navigating, Zoom court, and how it's progressed in terms of maybe set dates as well as trials and applications and things like that, and what you've liked about it, what you don't like about it, what you miss kind of from before, and what you hope sort of sticks around going forward.
Well, I'll start at the top with trials. Uh, this is an area where reasonable people disagree. I personally am not happy to do trials by way of Zoom. I'm just not that guy. A lot of people who I respect disagree with me on this point, but I just don't feel comfortable with that, especially when it comes to cross-examination of witnesses. Having said that, strict legal submissions, just submissions on the law, submissions on anything, that you can do by way of Zoom, no problem at all. But there is something very personal about cross-examining a witness, that an experience that you can't get by way of Zoom. That's my personal view. Even though logically, you can see my face better here on this screen than you would in a courtroom. You can see my facial reactions better here. You can see my face at the same time as you can see the judge's face and the Crown's face, for that matter, at the same time. Every bit of logic tells me this should work. And yet, the experience of being in a courtroom cross-examining a witness is still very different. Is it logical? No. Can I tell you why? Honestly, I can't. And that's why I say reasonable people do differ. Submissions on the law, no problem. I can do that. And I'm comfortable with that. And that's fine. But that's where I stand there about trials and applications. Going a step backwards, though, to non-contentious guilty pleas, non-contentious bails, and set dates, Zoom has been a godsend. And I think that everyone can generally agree with that. I do think that there will have to be a hybrid model, because even though Zoom is working great for me and for a lot of my clients, we also have to think about those people who don't have access to the Wi-Fi, don't have access to the devices, don't have access to the knowledge that's required to kind of get through the technology. So for those people, which is a significant number of people, there is going to be there will have to be something hybrid, I think. But a hybrid solution is what I would eventually recommend. What do I miss about going into court? Well, it's the camaraderie, right? Because on days when you do set dates, those are the days when you're hanging out with other people, other lawyers, staff, whatever the case may be. And that camaraderie, I'm not making light of it. It's important, but the convenience of just doing it at home or doing it at your home office or your regular office probably outweighs the sheer friendship factor of seeing your fellow lawyers in the lawyer's lounge.
Now, I mean, let's go take it back before obviously set dates. I think you had recently posted, so I can find it here quickly, about when you get arrested. When someone gets arrested, a client gets arrested, and I work as duty counsel, so I literally say, essentially, don't talk to the police, or the lawyer told me not to talk to you, or something along those lines, like thousands of times, if not even way more than that. But why is that so important? Let me kind of, here I got don't make a statement, innocent or not. You can't talk your way out of it. They will use the information against you. They don't just want to hear your side of the story. This is not your opportunity to tell your side of the story. Your statement will not get you released. And maybe you can kind of elaborate on that. I think it's excellent advice, and certainly explaining here to students who may encounter in the future, obviously, being on the other side of the call and telling people essentially not to talk. And I grapple with this, like I said, every time I'm working as duty counsel, because I have finite amount of time to really drill that message in. And then some of my colleagues will say, hey, you spoke to my client, here's a video of them just blabbing away, and you're like, wish they'd listen. What have you found has worked in that situation, and why is it so important?
Well, the reason it's so important is because many cases end up being statement cases. A lot of cases, a lot of times you're looking at your disclosure, you're reviewing it for trial issues, and you're thinking you have a legit shot at beating a case until you get to your client's statement. And that's when you realize you're sunk. You got to try and fight the statement. If you can't get the statement out, you're going to be in a tough spot. The law in Canada on voluntariness is still difficult for the defense bar. When you think about Oikel and Singh and Sinclair, it's tough. So the easiest thing, the best thing, better than getting a statement thrown out, is not having to deal with a statement. And this is true even if your client is innocent. Regardless of innocence or guilt, you don't want your client to say a damn word. Because if your client goes in and makes a statement, even proclaiming their innocence, that still can be used against you eventually at a trial. If your client, for example, takes a stand, especially if they take the stand. So if you go in there into that room and you say to the officer, "I'm innocent. I did not commit this homicide. At the time of the homicide, I was driving my blue car to the Shoppers Drug Mart." And then you're thinking, "Great, I didn't say anything bad." But then you go into court, you take the stand and you testify, and you say, "I'm innocent. I didn't do anything. At the time of the homicide, I was driving my blue car on the way to the Wendy's and the Shoppers Drug Mart." Well, now you've given the Crown some fodder to work with. "Oh, I see. Well, you're saying it was a blue car. Well, do you remember the statement? You said in the statement you said it was a red car." "Oh, yeah, I said it was a red car, but maybe it was a blue car. I wasn't sure." "And also in your statement, you never mentioned the Wendy's, did you?" "Yeah, but I mentioned the Shoppers Drug Mart." "Yeah, but you never mentioned the Wendy's." And then it all begins to fall apart. And that was a trite example, so forgive me for that, but that's what happens, even for your innocent clients, because once the Crown gets their hold on that statement, even if you're proclaiming your innocence, even if it's exculpatory, that's now something that I have to worry about. I got to worry about you taking the stand and saying something contrary to that. I have to worry about other evidence that comes out which may be contrary to that. Maybe the Shoppers Drug Mart has no record of you being there. Maybe the Shoppers Drug Mart, the security cameras broke down, whatever the case may be. And again, this is a basic example. So it is crucial that your client does not make a statement. Different lawyers have different ways of getting their clients to shut up. Usually it involves colorful language, which I'm not going to expose you to here, to your students. I don't want to corrupt them with my language. But whatever it takes to get your client to shut up, that's what you have to do. You have a, relatively speaking, short period of time, because you can't be on the phone with them all night, to explain to them the importance of being quiet, of not saying a word. And then you just hope and pray. Some lawyers suggest putting your head down on the table and taking a nap. Some lawyers will tell their clients to count backwards from 100 to 1. And then once you get to 1, count to 100, and so on and so forth. Some lawyers will just try and drill away to them the importance of just being quiet. Whatever method you use, it should work for that specific client. Different clients will react to different stimuli, to different types of instructions. Some clients, for example, will respond to the "shut the F up." Other clients will not, and they need a more gentle approach. So you got to try and suss out the client as well. It's a very difficult thing, but cases are won or lost based on what your client says in that room.
Now, if certainly as well over related to that, I mean, maybe we could start there in terms of just the process there. Once your client then goes and then they're held for bail. And now we've talked a bit, obviously, about Zoom, and one of the things that are different is bail courts being now done over Zoom and on the phone. What do you need to do in terms of preparing then for a bail hearing right after? I mean, either you would look at it from before COVID or after. What are the sort of the ways to ensure that you can get your client out if they're seeking let's say a detention on the secondary grounds that they feel that they might go on and reoffend? What are some kind of tips there? And I mean, just generally in preparing for a bail hearing, and how do you overcome that if after they are arrested that they want to hold them, let's say, on the secondary ground?
Sure. So if you're super duper lucky, and you probably will not be this lucky, but you might be. If you're super duper lucky, your client is aware that there's a warrant out for their arrest, or they're being, or the police are looking for them. Now, this puts you on an advantage because now you can put in place certain things before they even turn themselves in. So one, you want them to turn themselves in. You do not want, whenever possible, you don't want the police to find your guy on the streets or at their house or wherever the case may be. It is always to your advantage to have your client turn themselves in as soon as possible. Okay, so that's the first thing. Also, a lot of my cases are domestic cases with witnesses who are going to be recanting. First thing that happens once your client is brought into court is there's a no contact order. But before your guy is arrested, They can have contact. So it might be, you might even be able to get a statement from the witness even before they turn themselves in. And sometimes those statements can be helpful, other times not so much. But this is stuff that you can put in place before they actually get arrested. And most importantly, perhaps you can put retainer in place as well, because before the client goes in, it's easier for them to get their money in order than it is for them to get somebody or some relative to do that. So those are three things that if you're super lucky, you'll be able to get in place even before your guy is arrested. However, you're usually not going to be that lucky. So this is then what you have to do. Once you're on the phone with your guy at the station and you're trying to get them to be quiet, that's one of the crucial things you're trying to do. But also you have to get some important information from them. You have to get the information for their surety. You have to get their information for the person who's going to be fronting the retainer. Sometimes those are different people. Sometimes those are the same person. Or you may be getting the information, contact information for some random third person who will have the contact information for those other two people, whatever the case may be. Once you have that contact information, then you need to make some phone calls, and you need to speak with the potential surety, and then you need to speak with the potential retainer and get those two things in order. Bail hearings, as I frequently tell new calls and students, you need to know the law on bail, don't get me wrong. But bail hearings are won and lost on the story you're able to weave. And I don't mean a fictional story, because when I use the word story, people think it's like a fairy tale. No, it's a real life story about your client, but it is a story nonetheless of how your client got to where they did, the pitfalls, the ups, the downs, how their relationship with their surety, and what the surety is going to be able to do to keep this person on the straight and narrow track, be able to get them to abide by the conditions of their bail. So you need to find the surety who's going to be able to best tell that story. And then you guide them, you get the information from them that you need to be able to present that to the justice of the peace and create a compelling reason for your client to be released on bail. That was sort of intentionally vague, but we can go into as much detail as you feel is necessary or appropriate. But storytelling is the key for bail.
Well, that's great, and certainly, obviously, the facts of your client's situation are going to be the most helpful, so you can justify why you should be comfortable that they're going to show up to court and they're not going to be out past curfew because of the connection with their family member or friend who's going to be the surety there. Now, one of the things I think you brought up cross-examination in the context of Zoom and how it's more difficult to assess credibility, and I get this question all the time when we have mock trials and stuff. So maybe you could look at it from first, approaching a trial that, you're going to be cross-examining, maybe a police officer or something like that. And maybe how you kind of develop and prepare. I mean, it can be as vague. I mean, obviously, it's sort of general advice here for students in terms of trial preparation, and specifically what I find the hardest for students to grapple with is asking the right questions in cross-examination. And I think it's my cousin Vinny there. I remember seeing there's like the clip where you ask one question too much, and it's like the reading glass. It's the reading glasses and not the glasses for distance, and it just ruins the whole thing. So what kind of advice maybe in terms of, first of all, just look at trial preparation generally, and then specifically on how to better perfect or master as much as you can the tools of cross-examination?
Sure. So you want to start with an overall picture first. You review all your disclosure, you summarize everything so you know what exactly it is that you're looking at. You get your instructions from your client, of course. Once you know your overall picture, then you can begin to piece together what your defense is. How are you approaching the case overall? Once you know that, then you can look at individual witnesses and say, this is what I need from witness X, from witness Y, from witness Z. So if it's an alibi case, or if it's an identification case, and you now know it's an identification case, you can now look at the different witnesses and see how they contribute to their defense or how they hurt your defense. So so once you know, again, identification case, you can then look at the statements and say, what is my goal from this witness? I need to get from this witness that they couldn't see the altercation properly or the accused properly. I need to show that they were too far away, or they were colorblind, or they weren't reading their glasses, whatever the case may be. Witness B, what's my goal from this witness? What do I need to get from this witness? Well, from this witness, what I need to get is that the person who was the assailant was wearing blue jeans, because you know that your guy was arrested wearing khakis later on. So that's your goal for witness number 2. And then you can go through that with every single witness, right? Witness number 3, you read their statement or their notes or whatever the case may be, and you can read that they know that the assailant was covered in mud because the fight happened in a big mud puddle. And you know that your client, when he was arrested, not a trace of mud on him. And it was 5 minutes down the road. So you know that your goal from that witness is, I need to get the mud from this witness, or whatever the case may be, right? So once you have an idea of what your case is about generally, and what your case is about generally, and what your defense is about generally, then you can go break it down to each individual witness, see what your goal is for that witness, or goals, plural. And then you can craft your cross-examination in a way that helps you get to those goals, right? If your goal of your cross-examination is just, this witness is a liar, then that's a different thing altogether. But it's still, the idea is still the same, right? Your goal then for this witness is a liar. I need to show why this witness is lying about X, Y, Z, whatever the case may be. So then once you get to that witness, now you know what your goal is. You can take their statements, and then you can begin crafting your cross-examinations. Where are they inconsistent? How are they inconsistent? Are there issues in their evidence that make them patently unbelievable? Is their expected evidence inconsistent with the evidence of another person? So they say there was a red car involved, but you know witness C says that it was a blue car. Get that out, and make sure you remember to get that from witness C as well. Right? Because it doesn't help for you to make sure that a witness A says red car if you forget to get from witness C that it was a blue car. You know, so as you craft your cross-examination for each individual witness, that's also going to help you craft your cross-examinations for the other witnesses, because it all weaves together. It all becomes a story that you're trying to put together or break apart. So that's my method. Start with the overall picture and then break it down into individual witnesses, what your goals are for individual witnesses. And then once you have your goals for your individual witnesses, you have different areas of questions that you're going to try and put together in order to properly put together your cross-examination. Is that helpful? I don't know.
Yeah, that's very helpful, because as much as they're kind of isolated, they're also connected, because if you're focusing on the mud here and then you forget about it with the other officer, then you haven't doubled down on what's really useful there for you.
Yeah.
Now, what about in terms of just general advocacy? I think as well, just the first time you have a trial, or the first time maybe when you're articling and you got to address a matter. And I used to actually like when people from Hicks would come, because they'd have like 15 things, and I'm like, okay, I have a little bit more time to kind of get ready to what I need to say. But what can you share for any young aspiring lawyers or paralegals in terms of just getting comfortable with speaking in the court and making submissions, addressing the court, or whatever it is on your application? Does that come with experience, or how do you find a way? Well, what's worked for you in your 17 years of practice there in terms of getting comfortable with oral advocacy?
Well, part of it is just practice. That doesn't help very much, because practice just comes naturally with time, and that's an unhelpful thing to say. Sorry. I'm going to give you one basic tip. That's so basic, but it's a thing. This is a telemarketing trick, and you're going to laugh because it's just so silly. But I poop you not, it is helpful. People have a habit of ending their sentences with an upward inflection. Makes it sound like you're asking a question. Get rid of that. It's a very basic thing. It's so basic. But once you notice that you do it, and then you stop doing it, you will realize that you sound way more persuasive, way more authoritative. So that is a super basic tip that I give to all students. Get rid of your upward inflection unless you mean to have an upward inflection. I learned that in telemarketing, oddly enough. So there's that. Beyond that, I use the word a lot, and someone just made that comment. We all have those things, but what you'll learn is that if you have certain phrases, certain vocabulary that you can generally just insert in as filler of time, that's helpful. So avoid your ums and ahs, and then you'll learn the things that you can say that will just kind of fill in the space. Take your time, slow down. You will and ah less if you slow down, think about what you want to say before you say it. In general, slow down. I don't know who's watching this. I don't know how many people are watching this, but I can guarantee you that 95% of you speak too quickly. Slow down. It will allow people to understand you. It will allow people to take your point. It will prevent you from making the ums and ahs that I was just talking about. Slowing down will very much help your advocacy. It will also help you think, give you opportunity to think. Thinking on your feet comes with time. However, the preparation part, try not to, when you're preparing your submissions, try not to use a script, because you will invariably go off script and then you will freak out because you will realize you are off script, and then you'll flub things all over the place. You don't want that. Try and make your submissions not with a script, but with point form. Point X, point Y, point Z, and so on and so forth. That way, you look at your sheet of paper and you see a point. Okay, this is the part where I have to talk about the mud. And then you just talk about the mud. Next point, this is the part where I talk about the khakis. Talk about the khakis, right? This way, it prevents you from sticking to a script, because invariably, if you are on a script, a judge will ask you a question that will take you off your script, and then you will struggle to get back to where you were. So the biggest things I would recommend, one is the silly thing, get rid of your upward inflection. 2, speak slowly, slow down. 3, do not script. Try and make it natural. Don't be someone that you're not. Bring your own cadences, bring your own style, bring your own voice to your submissions. You will listen to other lawyers, great lawyers, not so great lawyers, and you will pick up little bits and pieces from them, and that's fine. That will contribute to your style as an advocate, but make sure that when you do that, you make it your own. And you only take things from other lawyers if you feel like it's natural to who you are. Some lawyers are way more formal than others. That's who they are. Some lawyers are a little bit more casual. Again, that's who they are. You have to decide who you are. So that's the fourth thing I would do, I would suggest, is ultimately be yourself. Do what comes natural to you, because if it's unnatural, then it'll come out, it'll show, and it'll crack, and it'll fall to pieces. You don't want that. So those are some general tips for advocacy.
Thanks. I think those are great tips there. I think for those listening, certainly you can pick up on them. And if you're not casual, you don't want to try to be casual, and then you sound really robotic. It's like Kawhi Leonard making a joke, right? It doesn't come off really, although you can make it work for yourself like it did for him there. But now, I mean, speaking of that, actually, I know obviously, you have a presence on social media there, and we've talked about some of the stuff that you do, and kind of a mix of law, about your children, as well as, just basketball. I think, I guess you were wrong about the Suns there coming back to win, but I don't know, 4 in a row from the Bucks was unexpected there. But what is your thoughts, I guess, with mixing kind of obviously the profession there in law Twitter? Sometimes it could be like a dark place, and obviously, with people like you are sharing great advice, ask me anything types of questions. How do you kind of get into it, and what can you share? I think one of the things someone had asked you not too long ago was, this imposter syndrome, right? That everyone seems to be talking about. Hey, I'm afraid to be posting or asking questions, whether it's on like the listserv or on Twitter. And what if I don't really know anything? And how do I connect with other students and help build, other lawyers as well? What can you share kind of? I mean, I think from that, I mean, there's kind of a lot in there, but first from your experiences with social media, then as well of what students can do to, whether it's just starting with following people, connecting with people, and how to get over that kind of imposter syndrome.
So social media, I'll summarize how I got started. Someone set up this Twitter account for me, and then at first I thought I was going to be Mr. Smarty Pants and say all sorts of interesting things about the Supreme Court of Canada and Justice so-and-so's latest decision, and no one cared. There are lots of people who do that, and they're very good at it, and it's not a cheap shot at them because that's who they are. But just like in court, if you're going to use social media, make sure it's your own voice. Don't be something that you're not. Be yourself. Keep in mind, one thing that sometimes I fail at this, just so you know. Keep in mind that everyone is reading it. You have to keep in mind that there are, I'm not going to say who, although I know some, there are judges with burner accounts who are reading your tweets, judges who you will appear in front of. And you don't know who they are. And I'm not going to tell you. Not to mention Crown attorneys, not to mention potential clients. So first things first, some ground rules. Never say enough about a particular case detail that people will be able to identify what case you're working on. Even when I tweet about cases, generally, I think what I end up doing is, did we freeze? Have you been hearing me?
Yeah, I think it kind of froze where you were talking about specifics of a case, I think. So maybe if you want to back up there.
If it froze, that was the part where I said the most brilliant thing of the day, and now you'll never know what it was. It's gone forever. But don't say anything too specific about your case. Is important. On social media, be yourself, but be the version of yourself that you would be at a formal dinner party with judges. So think of it that way. If you got a joke in your head, and this is a joke that you would tell at a formal party with judges present, go nuts. Tell your joke. But if your joke is such that you would not tell that joke in that professional scenario, then do not tell that joke, right? And that's a general rule. If you're willing to say it in those circumstances, then more power to you. But that'll help people and some people, and that'll hurt others. Also, keep in mind your potential clients as well, that they're reading it as well. So you have to be sensitive to that as well. Don't joke about your clients ever, 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 right? They're relying on you. They don't need you joking about them per se. Again, nothing should be that specific. But this dovetails into the next thing that you had brought up, that if you try and be yourself, this version of yourself, which is still you, this will help you then form connections, is my hope for all of you. That people will get to know you and you'll get to know them, and then you'll make those connections that you otherwise wouldn't be able to make right now because of the world that we live in, because we don't have a lawyer's lounge to all hang out in, unfortunately. It's different. It's very different, but it is also genuine. A lot of people who I know only on social media, and I mean only on social media, are people who I weirdly would consider legit friends. 3 years ago, I would never have envisioned that. I would think it was crazy to think of someone who I've never met in real life. I only see their little profile picture this big, and this is a friend. And yet here we are. It's the world we live in. But just like in real life, you got to be yourself, and then you will find those people. I don't know. That was cheesy. Sorry.
I guess if that's the authentic version of yourself, then it certainly shines through there. And what about, I guess, making those connections there and using that to network? I mean, obviously, it's not like there is a lounge there that we can. I mean, in some places, I suppose there are places, but and we're slowly getting back to that. But how do you kind of, if you're, a young criminal lawyer or a criminal law aspiring lawyer, and you want to connect with people like yourself and all of the different ones that are out there, is it simple as starting to follow them, liking posts, and then maybe shooting off a message there, or what can they do to kind of get that confidence? Because I think it's a lot different today than it may have been 20 years ago, 10 years ago,
Mhm.
with social media. Obviously, that I remember when we would have like the OCIs, everyone would be deleting their accounts and no one would want to connect with people. But I mean, it's kind of the opposite now. What can they do to kind of get over that imposter syndrome and want to connect with people and share as well, without I mean, obviously people are afraid of, you post something and maybe you have a little thing wrong or people disagree, and then people start flaming you and harassing you. And certainly I think you were talking about women of color and people of color kind of get at the worst, but what can you say then with respect to that?
Yeah. So just one moment. I'm just checking something real fast here. Okay. So imposter syndrome is a thing, and I know it's hard when you're a new call, when you're a student. There are feelings of, do I belong here? You belong here. Let me tell you that right now. You belong. You finished school, you got called, you're a lawyer, you belong. In the criminal defense bar, generally speaking, we're a pretty easygoing bunch as far as answering questions are concerned. As far as shooting ideas off of one another are concerned, you can usually find an ear for someone who's willing to help you out. Don't be afraid to send that message and say, "Hey, do you have time? If you don't have time, that's fine. Whatever, whatever." And if a person's busy, they either won't respond in a prompt fashion, or they'll say, "Hey, I'm too busy right now. I can't talk right now." You will quickly figure out who are the receptive people out there, who are the people who are more willing to help than others, and then exercise your good judgment, right? I mean, you know how it is. If someone is willing to help you out once, then don't blow up their phone at 3 in the morning, and they're willing to continue to helping you out, right? So for example, I'm a lot of younger calls, the newer calls, and junior lawyers. They give me a shout and they ask me questions. Thankfully, I'm not getting 3 a.m. calls. If you're reasonable, I'm going to talk to you, and it's not just me. There are a lot of lawyers out there. So, other than assuring you that we're here to help you, I don't know how I can get you over your imposter syndrome, but I can assure you, we're here to help you. We want you to succeed. We want you to do well. We want the next generation of lawyers to be better than the previous generation of lawyers, because they were a disaster. So you're going to be better. We're going to get you there. And if we're busy, we're busy. But someone is out there who's going to be able to help you. I don't know how helpful that was, but I'm hoping it was.
And one of the things there, kind of, we just sort of talked about it before that, and certainly in the context, obviously, of just talking about like which of your kids there is the culprit of the door hinging mystery. But what are ways that kind of you can kind of let off steam there? I mean, it's a profession that I've talked to plenty of criminal lawyers, and we're dealing with so many different facets. Obviously, people's lives hang in the balance there in terms of kind of taking care of yourself, your own mental health, and ensuring that you can kind of be the best version of yourself for your clients. So what kind of worked for you? And um, I suppose obviously you helped a lot of people with posting about that motorcycle picture there, but what else that you find that kind of helps you get through everything, and anything that you can share with students who are obviously with the pandemic, it's also added to that another log on the fire, so to speak.
Yeah. So for me, I have my hobbies, and I'll share with you in a moment my personal ones. I don't care. I'm happy to share. However, having said that, let me tell you that the previous generation of lawyers, say senior to me, so I'm 17 years out. Let's say 25 years out or more. I'm going to tell you a secret. They're not well balanced. A lot of these lawyers are working themselves to death, and it's horrible. My generation, 15, 17 years old, we're doing it too. Don't get me wrong. I want your generation of lawyers, this newer generation of lawyers, new calls, you have to do better than us. You have to have a better work-life balance than we were able to maintain and we are able to maintain. Okay. So in a way, I'm kind of not the best person to ask this question because I'm part of that generation that's still kind of working ourselves to death. I'm not as bad now as I used to be, and I'm definitely not as bad as other lawyers I know. But your generation, this newer generation, I should say, you have to do better. So this is something where you should not be taking tips from us because we don't know. We're not doing it right. Having said that, I've got hobbies. So, and it can be stupid things. I, play with my kids. I got to take care of them. Apparently they have to eat every single day. Who knew? I read comic books. I play with Transformers on occasion with my kids, sometimes not with my kids. Whatever gets you through the day, right? But it's important at certain points in time, you have to put away the law. You have to close your laptop. You have to close your book, shut down the quick lock or Canly or whatever the case may be. You have to do this because your failure to do that will lead to you burning out. You burning out is not good for you. It is not good for your pocketbook. It is not good for your client. The extra work you're putting in, killing yourself now, may help you a little bit as far as getting your work done now, but in the long run, it will not help you. So you have to be willing to turn it off. If social media is your thing, then it's social media. One thing I try and do is talk about other things that I'm doing, things that are not necessarily the law, because one thing I learned was that when I started doing that, other people were also able to relate and say, hey, here's this lawyer. He does things that are not the law. I do these things, or I do similar things. I can talk about it too. And the more we do that, the more we share, the more we realize that we're human beings with lives outside of our legal careers. So that's one thing that I've done, and it's also helped me see that as well too. So it makes it easier for me to put down the case book every now and again, knowing that I'm not the only one. There are other people who try and do it as well.
Kind of related to that, I think every criminal defense lawyer gets this question at least once, if not 100 of times, and they have probably their own answers to it. But essentially, it's how do you kind of sleep at night knowing you represent some people that are facing serious charges, and you're viewing very serious disclosure, and kind of how do you, in light of we were just talking about mental health, kind of cope with all of that while you're dealing with so many things out there. What do you sort of say when people kind of like look at criminal lawyers like, oh, you're just helping people get off on technicalities? Now, what's sort of your response to that?
Yeah, well, it depends on who I'm talking to. There's different ways to explain it to different people. One thing I always say is that, for example, the charter is not a technicality. The charter is not technical. The charter is the supreme law of Canada. Beyond a reasonable doubt is not a technicality. It is the founding principle of how the criminal justice system works. These are not technical, and to call it technical belittles it. And that's not something that I want to ever do. Having said that, it's hard what we do. We deal with different difficult cases. We deal with difficult fact scenarios. They're difficult for our clients, especially, but also witnesses, complainants, the community at large, and we're at the heart of it. How do you do it? I don't know if this is the right mental health answer, but to a certain degree, there's some compartmentalization going on. At a certain point, you just have to shut it off and go do something else. I don't know if a mental health worker would say that's the right answer, but that's my answer. That's one thing that you have to be able to do is separate yourself and your life from the work that you do. That's one thing that'll help you. Otherwise, you're going to have all the sleepless nights. You're not going to be able to. You're not going to be able to get through your career because you'll see the complainants. You'll see the innocent people who've gone to jail unjustly on your watch. It will happen. You will lose cases where the person was innocent, and you will lose sleep over that. How do you get over that? Everyone has their own way. Just try and make it healthy. Unfortunately, some people turn to that if possible. Some people turn to alcohol, drugs, cigarettes, whatever the case may be, other unhealthy things. You have to try and stay away from that because you can get lost in all that. The way we deal with the criminal justice system and how we sleep at night uh, is by understanding that our role is crucial. Without having a vigorous defense bar to defend people who may be the least worthy of our services, we protect everyone, because innocent or guilty, everyone has a fair trial. Everyone should get a fair trial. And if we don't do our jobs properly, then our clients don't get a fair trial. And as a community, we all lose. So we have to do our jobs right. We have to work hard, and we have to give it our go. And that's how you sleep at night, knowing that the person who you represent, innocent or guilty, but let's focus on the guilty. Even if they are guilty, when you do a good job for them, you're not just doing a good job for them, but you're doing a good job for the community as a whole. That was definitely babbling. You can't tell me that wasn't babbling. I babbled.
Oh, I thought it was a great answer there in terms of certainly, our justice system is founded on everybody that was treated equally under the law. So if we're giving everyone, even the person charged with murder, the same treatment as anyone, then we can say we're very satisfied with the outcome there in our justice system. Now, just got one sort of thing there. I mean, certainly, I know you had joked about kind of sometimes being mistaken as like the Punjabi interpreter, and I think others of color certainly sometimes, and other uh,
Mhm.
groups there certainly for who don't kind of fit this, you are a typical lawyer. Any advice there for those kind of who are going to go through the profession? And I know we all have our anecdotes of things, where you're being mistaken for like different people and the accused and stuff like that. But what do you kind of, how do you get a thick skin and say, look, that you were saying before, you belong here. We all belong here. It doesn't matter who we are, where we come from, but anything that you can kind of share for students of color getting into a criminal defense bar that it's a lot more diverse than it was maybe 25 years ago. But any advice that you have from them?
Sure. Uh, this may or may not make you feel better, but I can tell you it was worse when I started. I was asked if I was the Punjabi interpreter, the Hindi interpreter, the Urdu interpreter, the Farsi interpreter, the Arabic interpreter. No one ever asked me if I was a Norwegian interpreter. That never came up. But I've been all sorts of interpreters for all sorts of people, allegedly. It was worse. Is it getting better? Yes. Now, you may not feel that way, and that may not, you may not find that answer particularly helpful. Because that, I don't mean to minimize what you are going through if you're a person of color, if you're a woman, or you are, or you're a member of the LGBTQ plus community, etc. When you're a member of these communities and you're feeling excluded and you're feeling that imposter syndrome, it's not particularly helpful to say, well, it used to be worse. Well, F you, it's still bad. So, however, I'll start by saying it used to be worse. What tips can you use? Well, the thing you can do is to get a thick skin is you have to talk to each other. And that way you understand that it's not just you. And that's helpful. Because when you hear those stories from 17 years out, or a lawyer who's 50 years out, or 20 years out, or 25 years out, and they tell you their stories, and then you talk to one another, your own cohort, and you hear each other's stories. And then you begin to understand a couple of things. You understand that it's not just you. And that's important. And that's something that'll help you get through the day, knowing that it's not just you. And as horrible as it is, it's not just you. But also, it helps you understand the importance of diversity and the importance of ensuring that our criminal justice system is reflective of everyone, not just certain communities, not just certain genders, not just certain ethnicities, whatever the case may be. So your presence is helping. Your mere presence is helping. You being there is making a difference. You talking to one another is being a difference. When someone calls you the accused and says to you, "Sir, with the dreads, is your lawyer here?" And you say, "No, I am counsel to that judge or crown or whoever the case may be." you are making a difference, that mere statement. When someone says to you, Miss, you younger female, are you assistant to counsel? Is the lawyer here yet who you are assisting? And you say, no, I am counsel on this matter. You are making a difference. That statement is making a difference. And the more of you, the more of us who do this, the better things will be. Right? Same thing. When someone says, sir, are you ready to argue your case? And you say, excuse me, it's Miss. I identify as Miss, or identify as neither, or whatever your pronoun of choice is. The statement matters. And the more of us willing to make this statement, the better it gets. And that's how you develop that skin. Talking to each other, talking to people senior than you, and being present. Your presence matters.
Now, Harpreet, thank you so much for joining us here and sharing such valuable insight. Both in terms of the sort of substantive stuff there and kind of what we were just talking about there at the end about social media, diversity, mental health. Certainly very important. And I know you do an excellent job as well on social media there in answering questions from students, younger lawyers, as you mentioned before. And where that Punjabi interpreter come, I think that was the first thing, in the 17 things you learned from practice of 17 years. So maybe we could, and you don't necessarily have to recite that whole list there, and certainly people can follow you on Twitter there to get more about that. But any final valuable words of wisdom there for looking back on your time for those coming in, anything that you can kind of summarize, and we really appreciate you taking the time here and joining us.
Sure. One, I'm not the Punjabi interpreter, but we've already established that. Two, get retained in advance, because after the trial is done, win or lose, it will be very difficult for you to get retainer, either way, either direction. Other things that I've learned, and hopefully that I can impart upon you and your students as well. After a criminal case is complete, no one is better off than when the criminal case started. This includes the accused, whether they are innocent or guilty, whether the complainants, whether they are lying or telling the truth, the other witnesses, again, whether they are innocent bystanders or thoroughly emotionally invested. When the case is completed, no one is better off. Everyone ends up in a worse place. Your job as counsel is to try and help your client get through this criminal justice system and try your best to minimize that damage, regardless of their innocence or guilt. You will be dealing with the most fragile, most vulnerable, most impoverished, marginalized sectors of our society in the criminal justice system, for better or for worse. So it is imperative that you work your best, you do your best work for them, because working for them is working for the entirety of our community. What you are doing is more important than just innocence or guilt, is trying to extract people who so often are just forgotten, trying to extract them from the criminal justice system, not just get them through it. Your work is crucial. You can do it. I have faith in you. That's all I got.
Perfect. Thanks. So again, you can follow him on Twitter there and connect with him further. Thanks so much, Harpreet, for joining us here today. And thanks for everyone for tuning in. I hope you learned quite a lot there about criminal law and a number of things related to practicing criminal law. And hope we see you again later this week. Take care, everyone.
Take care. Bye-bye.